Welcome to Legal Voice. In today's session, we'll be looking at Administrative Law Talk 2. So, without taking much time, let's get started with today's session. In today's session, we'll be looking at nature and scope of administrative law. Okay, basically, we'll be looking at what constitutes or what makes an administrative law and what is the scope of administrative law. So, as far as administrative law is concerned, it is concerned with the general public law. So, general public law, like the society is very complex. So, you have to organize and you have to see that the work moves very smoothly without any hindrances. And in this aspect, administrative law plays a major role. Okay, it acts as a regulating body. It acts as the main body which controls the functions of the state. Without the administrative law, the policies of the state may not be properly reaching the common man. So basically, it deals with general public and it is related to the public law. Now, so it deals with powers and functions of the state. Okay. Now, state always works for the welfare of the common man. Unless and until the power is not distributed and each department is not specifically given their functions, okay, the work at the state level may not be functioning properly. So, to ensure that the work is properly handled, there are various departments formed, and these various departments have their own powers and functions, so that altogether, when in an integrated way, they give or render a productive work. For example, if you take a state, so the state has various departments, like the state has an irrigation department. Now, what are the functions of irrigation department? The irrigation department looks into water resources. Okay, like it looks into climatic changes. It's one of the functions is to alert in case of cyclones. Okay, other function is to keep an eye on uh, the agricultural resources, especially the water resources. So during the time of cyclone, the agriculture department plays a major role to keep a check on the water level in the dams. So whenever the water level risks or reaches a risky point, they alert or it alerts the other administrative department at the district level so that preventive measures are taken and lives are saved. In the same way, if you take the police department, okay, so the police department is also empowered with the powers. So it has powers whenever there is an unlawful situation happening or a crime is happening. Okay, the police is empowered to take necessary actions to see that the crime is under control. So it also functions as uh, it also functions as a main body to see that uh, there is no disturbance in the society and the work in the society flows smoothly without any disturbances. Okay, basically, administrative law is a law made by the administrative authority. So authority is a body, okay, which which is empowered or which is assigned powers and functions to handle the specific task of the state, okay, at various levels. Now, basically, administrative authorities can handle two functions. So the functions are they handle rules, okay, rules of authorities, like uh, how they should function. So rules are the guiding principles. So and orders. So orders or statements or uh, official documents which state the powers, the capacity building is done by the orders. Okay. An authority may not function without a proper order. So an order is an authentic document assigning or giving rights to the other person to handle the things. Okay. Regulations. So necessary changes. So whenever there is a change in the society, there is a change in the situations. Okay. So the change in situations can be handled by the regulations. Okay. So regulations are in short time to time changes that are brought in the administrative department, which have to be regulated, which have to be handled in a better way. For example, a law that has been or a rule that has been set in the past may not be appropriate to the present situation because the present situation has completely changed. So the rule has to be regulated. The rule has to be changed uh, with the current scenario, with the present situation. So administrative authorities deal with rules, orders, regulations, and bylaws. Bylaws or the laws that are brought by the state. So they have to update. They have to be aware of the laws of the land and implement their roles and duties as per the uh, said laws or as per the laid down laws. Okay. Moving on further, it the administrative authorities also act as quasi-judicial powers. Quasi is something which is not real, but it seems as a judicial system. Okay. So administrative law cannot take up the duties or roles of the judiciary system, but it looks like a judicial, they look like they are applying the judicial powers. The main intention here is to regulate their duties, to see that the work is well organized and the work is carried ahead with the necessary care. Okay. So it does have this quasi that is seemingly or looks like judicial power, but not in reality pure judicial powers. Okay, to handle the task or to regulate the things at their hand, to see the smooth functioning of the states. Okay, so let's move on further. So they are empowered with special powers. So unless and until the administrative department is not assigned powers, they cannot perform their duties in a proper way. Like for example, if a particular incident uh, or a particular situation demands proper documentation. Okay, so the administrative law has the power to cancel the application if the application has been not be submitted fulfilling all the necessary essentials. Okay, like for example, some X is allotted a house. Okay, now as per the administrative law, he should furnish his identity proof, okay, and other documents. Okay, now if he furnishes those documents, then the house will be allotted to the person. And in case of this person failing to submit the documents, then the administrative system would have powers to cancel his allotment. Okay, so basically, they are empowered. They are given certain powers to ensure smooth functioning of the administration. Okay, so the powers will be again within the range. So they may not have or they may not hold the ultimate authority. Okay, they may not control the situations, but they can regulate. Okay, the main intention here is to ensure that the work is handled effectively. Okay, and increased functions of the democratic state. Now, year by year, the population rate is increasing. With the population rate increasing, uh, the complexity of administrative tasks at the state level is also increasing. Okay, which demands a more strengthening and more effective administrative system, especially in the case of states. Because when there is an overall development happening in the state, it also becomes essential to see that the state functions properly. And functioning of the state may not be effective without an administrative law. So its functions have increased in many folds, we can say. Now, other aspect is it ensures administrative law ensures individual rights. Okay, individual rights in the sense like if someone is eligible for a particular thing, so how that particular thing will reach? It will reach only through the administrative system. And in case of social justice in the sense all are equal in the eyes of law. Okay, they should not be biased nature. They should not be uh, ups and downs in the judiciary. Oh, sorry, I mean to say in uh, assigning the things or in the distribution work. So it ensures that everyone is treated equally. Okay. Security. Administrative law plays a major role in ensuring security. Security, when we talk about when there is a deviation or when there is a difference of opinion. Okay. So the administrative law plays a major role in not only protecting but to ensure that the government assets, the public property is being protected and it is not misused or it is not going in the wrong hands. Okay. And the administrative law clearly lays down powers and functions of the administrative authorities. Now, everyone cannot do everything. So unless and until the roles and powers are segregated, so the functioning of the state may be a big headache. So it clearly mentions a good administrative system should have a clearly laid down powers and functions, which authority has got which power and what are its functions. Then only there'll be a smooth functioning of the state. Okay. And further, functions of the state cannot handle without administrative law. In the absence of administrative law, the state may not function effectively because there are many departments, there are many things to be taken care of, and all the things cannot be taken care of few. So there should be strong administrative departments to ensure that the work of the state is functioning smoothly. Now let us look at few of the definitions of administrative law. In the words of Ivor Jennings, he says administrative law is the law relating to administration. So administrative law is the law related to administration. Now here the word administration, talks about managing the things. Okay, how things are managed. Okay, is it only managing things? No. He further adds, it determines the organization. Okay, it determines organization in the sense how the work is arranged, how the work is managed, its power and duties of the administrative authorities. Now, in this definition, he talks about administration. He talks about who has, how it has to be done, and what are the powers and what are the duties of the administrative authorities. But it fails to give or highlight the remedies. Okay, it doesn't provide necessary information how to deal with the things when things are not properly handled. Or in one way, though Ivor Jennings' definition of administrative law gives the basic inputs, but it doesn't talk about the limits of administrative law, where the administrative law ends or where the administrative law has to be empowered. It doesn't also talk about remedies of the administrative law. It just talks about the basic functioning of the administrative law. So it let's move on further with one more law that has been stated or that has been used to define the administrative law. In the words of Casey Davis, 1978, administrative is a law concerning powers and procedures, concerning powers and procedures, powers and concerning powers and procedures of administrative agencies, okay, including law governing judicial review of administrative actions. Now, the definition of Casey Davis is more focused on the rules and regulations of administrative law. It clearly states that it is a law concerning powers and procedure. So the earlier definition of Jennings talks only about powers and functions, but here he talks about procedure. Procedure in the sense when you have the power or when you have to delegate a function, how would you delegate a function? What are the steps that have to be taken? Okay, what are the different approaches that have to be adopted? Unless until you don't have a procedure, you cannot take the steps. Procedure of administrative agencies. Agencies are again bodies. Okay, like for example, police system is an administrative agency. Irrigation department is an administrative agency. Transport department is again another administrative agency. Okay, including special laws governing judicial review of administrative action. So the definition of Casey Davis also involves uh, the administration under the ambit of, or brings it under the ambit of judiciary. Okay, it has to also be framed, or it also needs to function following the laws and abiding to the laws of the judiciary system. Okay, so it is not an independent uh, department, or it's not an independent body, but it is a body which should follow the rules and regulations of the state, okay, which are regulated by the state. So Casey Davis definition of administrative law is better when compared to a definition of Ivor Jennings, but this also fails to explain about the remedies of the administrative law. Though it clearly talks to some extent the limits of the administrative law, but it fails to focus on limits of the administrative law. Okay, so let's move further to the next topic. Then we have the definition of Dicey. So Dicey also gave a definition of administrative law in the year 1885. In the words of Dicey, administrative law as that portion here, as that part, okay, as that part of nation's legal system which determines the legal status. Legal status in the sense, here again he is talking about the power and liabilities. Liabilities in the sense, what are the areas that it can control? Liabilities of all state officials. Okay, the first thing is it talks about legal status, whether it is uh, functioning on behalf of government. If it is functioning on behalf of the government, what are its powers and functions? So this should be clearly stated in the administrative law. Secondly, the second point is, secondly, defines rights and liabilities of private individuals in their dealings with the public officials. So the second part is, it should clearly mention if there is a problem, okay, how a common man can approach the government official. Okay, what is the capacity of this officials? Okay, who does which work? Now, as we have discussed earlier, all the works cannot be done by all. Okay, like for example, if someone has a problem with uh, his agricultural work, so if he takes this problem or if he takes this issue and puts it in the financial department, obviously the financial department is not concerned with the agriculture department. So the common man would be sent to an agricultural official who can understand the problem and can provide a right solution to the problem. And thirdly, specifies the procedure by which those rights and liabilities are enforced. So whenever there are rules and regulations, the rules and regulations have to be codified, have to be written down, and have to be approved. Okay, and there should be uniformity of the procedures so that everyone is getting an equal justice, and there will not be any scope of deviation or biased nature. So Dice's definition in a way touches all the important points, and it also talks about limits of the administrative law, functioning of the administrative law, powers of the administrative law, but does not speak much about the possible remedies which an administrative law can extend. So let's move further. So let's move further and see one more definition. So according to Jane and Jane, the administrative law should mainly deal with power and functions of authorities, administrative authorities. See, unless until proper power and functions are not assigned to the administrative authorities, they may not ensure quality work. Okay, so power and functions of administrative authorities should be crystal clear. and then only they can function smoothly. Second, limits of administrative authorities. Okay. Now, if the administrative authorities have no powers, then also they cannot render quality work. If lot of power is empowered or given to the administrative authorities, then also there may be future problems or future problems or issues that may arise from one department, one authority handling multiple departments. So there should be limits. So if there is a department, the department should take care of only certain areas. Okay. So if all the authorities are into all the departments, then there'll be a confusion, and it may not be stated that in such a case that the state will be able to perform, and the functioning of the state becomes an uphill task. Moving on further, it should prescribe procedures. Procedures in the sense it should very clearly lay down administrative procedures to the administrative authority. It should clearly state, okay, how a particular thing has to be done. What are the steps ought to be followed to ensure that the work is done. So prescribing procedures also ensures uniformity and quality work in the different administrative departments. And okay, one major area which was neglected by all or was not seen in all the previous definitions was remedies. Remedies means solutions. Solutions in the light of judicial system. So if something is not properly done, then there should be a way, there should be a solution for this. Without proper remedies, without proper solution, the administrative system may become standstill. It may get blocked. Okay, it may not function properly. So a good administrative system or administrative law should have all the possible remedies whenever something goes wrong. So how that particular thing that went wrong has to be rectified. So that should be clearly stated. Okay. Moving on further, uh, constitution law versus administrative law. Is there any difference between constitutional law and administrative law? Or both constitution law and administrative law are one and the same? So in the words of Keith, so which he has said in 2014, he holds that it is logically impossible, means in terms of thought process or in terms of thinking, it is impossible to distinguish. Distinguish in the sense you cannot draw a line. Okay, you cannot say constitution is law is different and administrative law is different. So there is a lot of overlapping. There is a lot of dependence on each other. So administrative law is incomplete without constitution law. And constitution law talks more about the procedures, okay, more about functions, more about the powers, okay, how a particular thing has to be done in a particular situation. So it very clearly lays down indirectly or talks about administrative law. So it is logically impossible to separate the constitutional law from administrative law. The subject of administrative law deals with constitutional law. Okay, both the laws deal with functions of the government. Okay, so administrative law also talks about functioning of the government, and constitution law also very clearly lays down about the functioning of the government. Okay, another important point is both are part of public law. Constitutional law deals with the common man. and it works, or its main intention is to provide equal justice to all. And without administrative law, the equal justice or the legal justice may not reach the common man. So both are very important aspects of the public law. Moving on further, in the words of Owen Hood Phillips and Paul Jackson, they stated that constitutional law is concerned with the organization and function of the government at rest. So, in the words of Owen Hood Phillips and Paul Jackson, the constitutional law is a static law. Okay, it's a static. Okay, because it is concerned with organization and functions of the government. It just talks about uh, functions or what a state can do. Okay, and what is its capacity. Okay, what are the different areas that it can handle. Okay, and the administrative law with the organization and administrative functions in motion. Okay, so in the words of Owen Hood Phillips and Paul Jackson, constitutional law is static. Okay, static, which means it just talks about the laws and procedures. It is administrative law that functions, that brings those procedures into functionality. So, administrative functions in motion. It is dynamic. Administrative law is dynamic and constitutional law is static, in the words of Owen Hood Phillips and Paul Jackson. There's one more view that is held by Maitland. So, in the words of Maitland, constitutional law deals with structure and broader and lays down broader rules. Okay, structure in the sense it talks about the hierarchy. So, who has to do which role? Okay, and broader rules means very clearly it should lay down the rules where the territory of one authority ends and the territory of other authority starts or begins. Then only it will be easy to regulate the functions. Okay, if by chance all the departments are functioning or performing all the functions, then it will be a confused state because the powers overlap, functions overlap, and this may lead to poor quality of work. Okay, whereas details of functions are left to administrative law. Now, how it has been functioning or how it has to delegate its work. So that purely depends upon the organization of the work within the administrative law framework. The administrative law cannot be separated with the constitutional law. So they are interdependent. They cannot exist without each other. So the administrative law has got nothing to function in the absence of constitutional law. And constitutional law lays down all the procedures or clearly states all the procedures. But again, without an administrative law, constitutional law may not be effective because without an implementation system, it just becomes a concept on the paper. Okay. However good the concept on the paper is, unless and until it is not implemented, okay, it may not be necessarily considered to be a uh, very good department or very good wing. So administrative law and constitutional law are interrelated and cannot be separated from each other. Okay, so the main thing is administrative law should provide remedies in the sense solutions. So whenever something has happened and that has happened as a legal issue, so there should be a proper protection under the law, and that proper protection is provided by the provided to the administrative authorities, which is available to the aggrieved parties, in the sense the parties that have been uh, victims, okay, that have been aggrieved, can be found in the Article 32 and Article 226 of the Indian Constitution. So this brings us to the end of today's session. I hope that all of you have got good inputs from today's session. Okay, have a good day, stay blessed. Okay, and please do forward this good work to your near and dear ones. Okay, so see you in next class. Thank you. Have a good day. Take care. Bye.